If you've been furloughed and you're wondering how that's going to affect your support obligation, please hang on because I'm going to have some answers for you, regardless of the state in which you find yourself. Hello, my name is Carla Hartley. I'm the managing partner for Hartley Law Group. We are licensed to practice in Texas and California. We have attorneys licensed in both states and attorneys licensed in each single state. We've been getting a lot of calls, even from people who are not our clients, about what is happening with the furlough situation and how does that affect your support. One thing we are seeing is in various states, whatever governmental agency is handling the child support services, they are often saying they can do an abatement and not collect while the furlough is in progress. Well, that doesn't mean that the support obligation has stopped or has been suspended. It just means they're not going to collect it right now. We are dealing with a lot of uncertainty, or at least a lot of these furloughed people are dealing with a lot of uncertainty. They don't know if they're going to be back to work in January. They don't know if they're going to be back to work next fall. They don't know if they're coming back to work. The other problem is we don't know, but we are finding that in order to ensure back pay for furloughed workers, Congress has to make an act or pass a bill saying, yes, you get paid for your furloughed time. So if you have, let's say you have a $1,000 support obligation per month, regardless of whether it's child support or spousal support. Some states I know don't have spousal support. Thank you, Texas. But let's look at this either way because many states do have spousal support. If you have a $1,000 a month obligation for support and you are furloughed and the state is not collecting it right now, or your opposing party, your supported party is saying, no, 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 you don't need to pay me right now. Here's the problem. Most states do not permit you to retroactively modify support. That becomes a large problem in those states because the support obligation continues to accumulate. You have a support obligation of $1,000 a month, and let's say that you are called back to work in January. Well, you've been furloughed since September 1st, October 1st, depending on who you are. So you've got a support obligation of $1,000 for October, November, December. You go back to work in January. So you've got $3,000 in arrearages. What if Congress does not vote to make you whole and pay you for those 3 months? You're still, in many of these states, going to have the $3,000 of arrearages that you have not paid. And in some states, that sets you up for, shall we say, a contempt charge. Now, it's defensible because contempt in every state depends on an inability to comply with the order. But saying that you cannot come up with $1,000 a month for support in some states is not well considered. In other states, it would be a valid defense. Now, let's consider how it doesn't hurt you. Say that you have been furloughed and you come back to work in January and Congress votes to give you back pay. You get a big check and you're able to pay the $3,000 in arrearages. It's no big deal. How long are you willing to gamble that Congress is going to vote to pay you for time while you were not being actively employed, while you were not showing up for work? I think you need to take this into consideration. The general remedy for this would be to get a motion on calendar and serve it and set it out a few months so that you will know by the time you go to court if you were reemployed. You will know by the time you go to court whether or not you are going to get that lump sum payment. I think that is a reasonable and safe alternative in any case when you're looking at possibly ending up with retroactive child support or spousal support arrearages. If you are in a state that permits retroactive support modification, great. It's up to you, depending on your individual state, to either call a lawyer, call a self-help center, or do the research for yourself and find out if your state permits retroactive modification of ongoing support orders. Now, let's consider an even worse scenario that could occur. The government doesn't ever hire you back, and you have not at any point in time filed to modify, You're in a state that does not permit retroactive modification of support. And now you're 8, 9 months in, you have been permanently laid off, and you now owe $8,000 or $9,000 based on that $1,000 per month abated or deferred collection that the state or your ex has not chosen to go forward with. This is a sticky situation. The easiest way to handle this, again, to ensure that you don't end up in that particular scenario with that kind of a debt, file the motion. I don't know if you need to hire an attorney. You might need to go to self-help. It depends on what you're doing. Depending on the status of your case and where your case is at. Is it pre-judgment? Is it post-judgment? Is this going to be a post-judgment modification that you maybe should have looked at any time in the past 6 months or 2 years? Go ahead and be safe. Be safe. Contact someone in your state who knows what they're doing. Don't just depend on the support department to say, yeah, we're going to abate it. Abatement, deferral, those are abating collections, not dismissing or modifying or vacating the order for the months of the furlough. Deferral is the same thing. It's deferring collections. It's not deferring the actual accruing arrearages during this time. Okay, so I hope I have been helpful. I hope I have given you something to consider. And I hope those of you who listen to this will actually take the next step. Call an attorney, call a self-help center, call, I don't know, a practicing paralegal in your jurisdiction and find out, one, does your jurisdiction permit retroactive modification of whatever type of support obligation you have? Two, if they do not permit it, file the motion. Get yourself on calendar and protect yourself. You can set your hearing out a few months and get past all of the maybes, but file and serve your motion. You can explain to your supported spouse or your supported child's parent why you are doing this, and I am sure they will understand. The exception might be if you're both furloughed, but even in that case, I think you should consider, get together, look at the numbers, and maybe think about how this is going to affect you and which one of you could end up hurting. Play it safe, people. I hope no matter where you're at, doesn't matter if you're in California or Texas, wherever you are, be smart about this. Please don't dig a hole that you can't get out of or that's going to really hurt you to get out of by inaction and putting your head in the sand. Play it safe. I hope I've been helpful. I hope that you will take action if this is affecting you and that you will protect your own best interests.